Hi guys, it's Kathy. I hope you're doing well. So we're still on January 30th, 1995, part 4, but it's the last part of part 4. And in about 40 minutes, there's a big spike in views of this video. I don't know why. I don't know what happens, but it happens in about 40 minutes once I press play. Depends how long I talk. Right now, it could be 80 minutes. No, joking, 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 joking. Now I hope you're back inside and warm. All right, let's get to it. Let's get to OJ.
Your Honor, I'm appalled. What does counsel think is his job to mislead and to sandbag and to ignore the law and to flaunt the law?
All right, counsel, I'm just
Okay.
I just asked Mr. Cochran for an explanation. Is there a statement of Rosa Lopez that contains attributes to her the comments that Mr. Cochran made today and the day
Right.
before?
This
That
is
was
their
my
witness.
question.
Yeah, this is their witness. And when they take a further statement from a witness, they're obligated to turn that statement over. And as we always have. There have been multiple statements for some witnesses in our case, and the prosecution has never been derelict in its duty, has always fulfilled that duty to
All
turn
right.
all of them
Well,
over.
Ms. Clark, here's the problem. There's been a representation made to me that no such witness statement was taken. All right?
Nevertheless, obviously, the statements were made, weren't they? And we were given no notice of the fact that the witness made further statements that are of a much different nature.
Right. When that witness is called, you may make a new objection, and I will contemplate precluding that witness from testifying, based upon the fact that it appears that at the time of opening statement there was a clear intent to do that, that no statement was in existence, that additional statement was not disclosed. I've already made findings to other witnesses that this failure to disclose was intentional and deliberate. You can renew your motion then, but at this point, I'm not going to entertain any further sanction as to Rosa Lopez.
We would not ask the court to preclude her testimony, Your Honor. We would ask an admonition be given concerning her testimony.
All right. All right, court will rule as follows. The prosecution will be allowed to briefly reopen its opening statement. It will be allowed to go into inconsistent statements, specifically with regard to this case regarding Mary Ann Gerchis. Prosecution, because the defense did not disclose the identity and nature of expert witnesses who would be testifying regarding arthritic condition, may merely say that now that we know that this is going to be an issue, we're going to show you this videotape or these outtakes. Prosecution may mention the fact that Howard Weitzman was having not been disclosed, that the information that you have, the evidence you will present, will be that that was not in fact what happened, that Mr. Weitzman was in fact allowed, or however you feel the evidence will come out as to that. As to the allegations of misleading the jury regarding the EAP blood types, I'm going to defer ruling on that until I've seen the laser disc. I'm going to sustain the court's own objection under 352, undue use of the court's time as to the circle of benevolence argument and the Taft prenuptial agreement, because I don't think there's any that's a matter of interpretation that can be done through the evidence and not through presentation of the argument through opening statements. All right, and Ms. Clark, I'm going to give you a 10-minute time limit on that.
Very well, Your Honor, but we're going to need... I would like for the court to... I would like to await the presentation of the opening statement until we know the court's decision on the blood issue.
That's a much different issue. That doesn't go to sandbagging at discovery. That goes to the show and tell issue. That's a different issue.
But the resolution of it is the same, really.
Not really.
What other resolution could there be?
Well, that's a completely different issue that I'm not going to entertain until I see the laser disc. All right? But we have an hour left of court time. There are other sanctions that I can...
When he says an hour left of court time, it's more like football time. And there's an hour left in this game, so it could be many, many many hours.
Imposed besides that. But I'm not convinced that a sanction is appropriate in that case.
With respect to that laser disc?
That's correct. I want to see the exhibit itself. If the exhibit, this is my thought on that. If the exhibit, although highlights one section, if the rest of the sentence is visible and there's a complete sentence available, that was exhibited for a long period of time in great detail to the jury. It may not have been misleading in that context. And Ms. Clark, please don't misunderstand me. I realize the pressures that you're under, both professionally and otherwise, and I really appreciate them. But at some point in time, when we have our show and tell and we make rulings and we agree not to, or we waive objection to things, that should be the end of it.
I appreciate that, Your Honor. I think that...
I agree with you, that's an important part. I agree with you, that's an important issue. But I need to see it before I can rule on it. I've given you something that's virtually unprecedented in any criminal case I've ever seen, the opportunity to reopen, but it's a sanction I think that's available to me within the spirit of 115. But those are the only 3 items that I'll allow you to reopen on. And you have a 10-minute time limit. All right, now, after we finish that, then what are you going to present? I understand there's a tape recording I need to listen to.
Yes.
What is that? Tape recording of what?
Let me defer.
Mr. Darden?
On 2 matters, we have not seen any video outtakes. We'd like to see them before the jury does. And I respectfully suggest, Your Honor, that you might wish to repeat the exhortations the counsel made on the opening day. I do not believe that personally directed epithets add any grace whatsoever to this proceeding.
I was actually, Mr. Bailey, I think I've spent a lot of time jumping on them today. So I was waiting for one of you to do that so I could jump on you to make the point. So, all right. I have to balance my excoriations from time to time.
You wanted some information?
Yes, Mr. Darden, what I'd like to know from you is you indicated to me at Sidebar off the record that you were going to present apparently the audio tape of the 1989 or 1985.
We absolutely saw this. I'm going to bump it ahead. Hopefully, I don't know how we got rewound. I'm blaming my cat. I'm going to try here at like 40 minutes. Here's where it jumps up real high. So I don't know what this is. We're going to find out. Let's start here. So when we left yesterday, he had just gotten the laser disc, I think, right? Okay, we heard this too. We heard the 911 call. Let's just jump to right here because I'm excited to know what this is.
We're going to present witnesses who are going to tell you that that's not true. This is what our evidence is going to show, and that's all they're going to be able to say.
Okay, I just want to make sure, because Waxman's going to, for a lot of us, he's going to be coming in along with Skip Taft, and others who are going to say what actually happened.
I suspect so.
Thank you. Just want to make sure that was clear.
All right, no,
Thank you.
it's crystal clear.
Okay, thank you.
All right, as to the Roy Firestone tape, any comment, Mr. Cochran?
Yes. We're now to the trial evidence, Your Honor.
That is correct. Two issues we're talking about here are the 9/11 tape and the Roy Firestone tape.
Well, let me then take, you asked me about Roy Firestone first. Let me take
Yes.
Roy Firestone first. It's a television interview, Your Honor, and I'm not clear for what purpose this is offered. It seems to me that if they're going to call Roy Firestone, I'm not sure they're calling Roy Firestone or they're just going to play the tape. Seems to me they'd have to call Roy Firestone as opposed to just playing the tape. Is there going to be a combination thereof? May I ask that question first? There's some relevance. You're just going to play a tape, and is that all that's going to happen?
I don't know, Mr. Darden?
Well, I think the tape is self-authenticating. I don't think I have to...
We saw that. Is he watching the laser disc, I think?
All right, good morning, council. Back on the record in the Simpson matter. Mr. Simpson is again present with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, and Mr. Darden. The jury is not present. Counsel, just a couple of things before we begin. The record should reflect that I have received.
Oh, I was muted for that. Should I repeat it? I don't know. Okay, I'll repeat it. Fozzie was right and I was wrong, everybody. I muted myself for that.
From the defense, a 1335 motion, which we will be deemed filed as of today, Mrs. Robertson. And Mr. Cochran, any other comments before we resume with the jury?
Yes, Your Honor. If I might approach the podium. The court, I believe, received a copy of a letter that was sent to my office last night from Mark Partridge, the lawyer who was on the plane from Chicago to Los Angeles and sat next to Mr. Simpson. I would like, because I think it's relevant, to read this letter into the record, if I might. The letter, Your Honor, is dated January 30th, 1995, sent to the law offices of Johnny L. Cochran, Jr.
Your Honor, may I object? The letter speaks for itself. Counsel can simply file it with the clerk and make it a part of the record.
Or will.
And it was, attention, Pat McKenna, Your Honor, one of the investigators. Dear Pat, I was surprised to learn today that I am one of the witnesses the prosecution claims was not previously disclosed. On the Friday, Mr. Simpson was arrested. I called the LAPD to identify myself as the person who sat next to him on his return flight from Chicago to Los Angeles. I believe I spoke to a homicide detective. I was told they knew who was on the flight and would get to me later. He did not ask for my address or phone number. On October 6, 1994, Richard Crotzley, C-R-O-T-S-L-Y, an LAPD detective, called me. He said he had received a witness statement about me from the defense. I told him my story. He told me to send my notes. He gave me the following address: Los Angeles Police Department, Robbery Homicide Division, room 321, 150 North Los Angeles Street, Los Angeles, California, 90012. I sent my notes, the same notes I sent you, to Officer Crotzley in early December 1994. These facts seem inconsistent with my understanding of the prosecution's claims about undisclosed witnesses or witness statements. I thought I should bring this to your attention in case it is relevant to the procedure in the case. I also want you to know that I am scheduled to begin a 3 to 4 week trial in Chicago on June 5th, 1995, and would not be available to testify during that time. I'm away from my office until Wednesday, February 1st, but can be reached at, and he gave his phone number, sincerely, Mark Partridge. I want to read that for the record, Your Honor. Thank you.
For the record also, Your Honor, we have not received any such thing.
All right. Well, the real issue, I think perhaps Mr. Partridge misunderstands the issue. The issue was the July 1994 statement that he gave to the defense turned over to the prosecution. That's the issue.
Yeah, we think it was, Your Honor.
Yeah. No?
We think it was.
All right. Counsel, let me ask you one other question before we start with the jury. During the course of our discussion of expert witnesses now designated by the defense, if you recall, there's a possibility that one of our jurors has as one of her physicians, one of the doctors that is now on the defense witness list. So I want you to contemplate the ramifications of that, and we'll discuss it tomorrow.
We have, Your Honor, we'll be ready to discuss that.
All right. All right, just so the ground rules are clear, counsel, I'm going to...
Request denied. You need to stay right here. Quit your job.
advise the jury that I've allowed the prosecution a brief reopening of their opening statement
Amok.
to deal with three specific issues, and that there is an absolute time limit of 10 minutes. All right, any other comment? All right, let's proceed. Deputy Mayor.
Who wants to guess whether she goes over 10 minutes or not? I'm saying she goes over. I'm saying she draws out her conclusion, her last sentence, 3 or 4 minutes.
Yes. Yes.
Since Fozzie's gone, I take that back. I take back what I said.
Well, ladies and gentlemen, please be seated. With the reporter, please. All right, thank you, counsel. Let me give a direction to the still photographers here in the courtroom. Gentlemen, you are not to take any photographs of any of the computer screens that are on the counsel's desk or in the back row here. Understood? All right, and Ms. Hazlett, would you make sure that any other photographers who come into the courtroom are so advised? All right, thank you. All right, ladies and gentlemen, good morning. The court has granted a prosecution request to reopen their opening statement to address defense counsel's comments in his opening statement regarding 3 witnesses who had not previously been disclosed or whose statements had not been previously disclosed to the prosecution before trial, as is required by the law. You are reminded, however, that any statements by the attorneys in this case are not evidence and should not be considered by you as such. Ms. Clark, you have 10 minutes.
Good morning, ladies and gentlemen. Mr. Cochran made some comments about first of all, I'm going to talk about a videotape. It has outtakes of the defendant making an exercise video. And Mr. Cochran made some comments to you about the defendant's alleged arthritic condition. According to him, the defendant's arthritic condition became acute sometime after he played golf and after he'd been swinging the golf club on the evening of June the 12th at about 10 p.m. He said at some point after that, the arthritic condition became acute. Mr. Cochran told you that the defendant's physical capabilities are very limited as a result of that condition. The prosecution will show you evidence to the contrary. We will show you outtakes of an exercise videotape which was made by the defendant only 2 weeks before the murders. We will show you a portion of that videotape to demonstrate just what the defendant's physical capabilities really were on the evening of June the 12th, 1994. In it, you'll see the defendant just 2 weeks before the murders, that he weighed 212 pounds, which is what he weighed 15 years ago. That the defendant prided himself in that tape on being in good physical condition. You will see him doing push-ups. You will see him lifting his arms overhead. You will see him stretching, reaching, throwing jabs and uppercuts, and he does that for several minutes in this tape. You'll see him doing trunk twists, and this tape took hours to make. And then he came back after that day, went back the next day, and spent a lot more time doing that very same thing. We're going to show you that tape during the course of this trial. Second of all, counsel made reference to the fact that to a statement that Howard Weitzman, who was then the defendant's attorney, was not permitted to be present during the interview with the police officers on June the 13th. And you were told by counsel that they refused, that police officers actually refused to allow Mr. Weitzman to remain with the defendant during that interview. That is completely wrong. And in fact, what the evidence will show is that the detectives asked Mr. Weitzman to stay for the interview, but that he declined to do so, stating that he would prefer to go out to lunch, and that prior to that interview, he had had approximately half an hour alone with Mr. Simpson to talk to him, after which he said, "Go ahead," went out to lunch. And that is what the evidence will show. And that was after the detectives invited him to come in and sit during the interview with them. Now, lastly, you heard Mr. Cochran talk to you about a witness named Marianne Gerchis. Now, he told you about this witness. He said it was a very important witness. He discussed at some length what she would testify to, telling you that she claimed to have seen 4 men on the night of the murders, at least 2 of whom were Hispanic, so at least 1 or 2 of whom were wearing a knit cap, and that she saw them possibly running from the area of Nicole Simpson's condo on the night of the murders. Now, you'll be hearing a lot more about Ms. Gerchis during the course of this trial, but right now I'm just going to address a few points that the evidence will show that Mr. Cochran didn't tell you about. For example, she spoke to her friend Sheila Carter the day after the murders of Ron and Nicole. She told her friend, Sheila Carter, that she was not even at Bundy on the night of the murders. Marianne Gerchis had planned to go and look for an apartment in Brentwood on the night of the murders on June the 12th. The next day, she spoke to Sheila Carter and said she did not go to Brentwood on that night, and she was glad because there had been murders committed there the night before. But Ms. Carter is also going to tell you something else. In addition to the fact that she will tell you that Ms. Gerchis told her she did not go to Brentwood on the night of the murders, she's also going to tell you something very important about Ms. Gerchis' credibility. She will tell you about a statement which proves that Ms. Gerchis is one of these people who comes out of the woodwork in high-profile cases so they can get involved. And here's what Ms. Carter will tell you. Ms. Gerchis was obsessed with this case, and she talked as if she knew the defendant personally. She said that Ms. Carter would send her to the store to buy every Inquirer, every Star, and every tabloid pertaining to this case, anything that talked about the Simpson case. She would read it all, and she would save it, and talk about the case constantly. But she somehow never told anyone that she had been on Bundy on the night of the murders, until the time that Robert Shapiro started the hotline requesting that anyone with information come forward and call that hotline number. And it was right around that time that he put out the hotline number that Marianne Gerchis started to say, well, maybe I was driving by that area. Maybe I did see something. Mr. Cochran accused us of not telling you about her, and we didn't, because we didn't know about her. And if you believe her, she asked the defense attorneys if they would tell us about her, and they said they would. She spoke to Robert Shapiro, and Shapiro's people told her not to talk to anyone about her statement. And when they finished taking her statement, they told her they weren't going to use her as a witness. They spent hours interviewing her back on July 10th and July 12th of 1994, and they never told us about her. Now, that jury instruction counsel showed you about credibility of witnesses applies to all witnesses, ladies and gentlemen. The evidence will show that Marianne Gerchis is a known liar and a Simpson case groupie. Thank you for keeping an open mind to listen to all of the evidence.
Yes, please.
She still has 4 minutes left. Yeah, that's just awful. Be a Simpson case groupie. Imagine people who just follow celebrity court cases all the time. What a sad what a sad life they must have. Um, Conus was great about taking the other stuff out. They left this one in. I know.
All right, thank you, counsel. Mr. Cochran, you had a request?
Yes, Your Honor. As we've previously indicated to the court, we will at this time ask leave of court to exclude all witnesses, save the investigating officers Lang and Van Adder, and save two investigators from the defense, Pat McKenna and Bill Pavlik, and save the family, the exceptions regarding the family members in this matter. We would ask the court to exclude all witnesses and admonish those witnesses regarding discussing their testimony and also regarding watching television of these proceedings, which would be the same thing as discussing the testimony.
All right, any comment from the people?
People would ask the court for the same ruling with respect to all witnesses, to both sides.
I said all witnesses, Your Honor.
All right, so ordered. Thank you, counsel.
Thank you, Your Honor.
All right, Mr. Darden, Ms. Clark, are you ready to call your first witness? All right, call your first witness, please. And if you could, maybe we don't need all three chairs up there at the people's side this week. Perhaps we could get rid of one of the chairs and give you a little more working room.
Judge Ito. They were about to finally call a witness. They were finally getting to call a witness. And now you want to take away a chair. Judge Ito, please. Please, dear God, let's start this trial. Hi, Walter.
Over by the podium.
Yes, thank you very much, Your Honor.
Which podium would you like us to use? It doesn't matter.
Objection
Well,
to
my
moving the
preference
chair.
at this point is your preference, Mr. Darden. You're the trial lawyer. Be my guest. Why don't you just move it over a couple of feet, because I want to avoid our other problem, if we can. Thank you. All right, Deputy Checks, can you help Ms. Clark get rid of this chair, please? Thank you. Mr. Darden, why don't you just slide those chairs over just a little?
We're going to get no testimony today because of the chair.
All right, Mr. Darden, who is your first witness?
Sharon Gilbert, Your Honor.
All right.
As she approaches the witness stand, Your Honor, we have here a 911 audio tape. We like to mark it People's One for identification.
All right, People's one for identification. All right, Ms. Gilbert, would you step over here by the witness stand, please, by the court reporter? Mrs. Robertson.
Please raise your right hand. Do you solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Please be seated and state and spell your first and last names for the record.
My first name is Sharon, spelled S-H-A-R-Y-N. Last name is Gilbert, G-I-L-B-E-R-T.
Thank you, Your Honor. Good morning, Ms. Gilbert.
Good morning.
Ms. Gilbert, who do you work for?
Los Angeles Police Department.
And what is your job title?
I'm a police service representative.
And are you also a 911 operator and dispatcher?
Yes.
Okay. And were you a 911 operator and dispatcher on January 1, 1989?
Yes, I was.
And were you on duty between 3 and 4 o'clock in the morning on that date?
Yes, I was.
And on that date and during that time period, did you receive a telephone call?
Yes, I did.
And where were you physically located at that time?
I believe I was sitting on console 41. It's indicated on my incident, the console that I was sitting on.
Okay, so you're sitting at console 41.
Yes, which is what we determine as a primary position, and primary is 911.
Okay. Now, is console 41 located in a private office?
No, it is not.
Is it located in a cubicle?
No, we don't sit in individual cubicles. There are approximately 5 consoles side by side, all connected together.
I take it that there's a telephone of some kind in front of you.
Each console has its own telephone, and it sits to the left of each operator.
And are you provided with earphones?
Yes, we have headsets, individual headsets.
And are you also provided with a keyboard?
Yes, we have 2 computer screens and a keyboard for each console.
Okay. If you will, take us through the process and procedure that occurs whenever you receive a 911 telephone call. Okay. The call comes in and you answer it, correct?
Yes, when you're plugged in, we have what you call an in button. It stays in all the time, ready for a call to what you say drop in. And we have an indicator on the panel to the left that shows the address and phone number where this call is originating from. And it also comes in on my computer screen, which is the left computer screen considered as our status screen.
Okay. So whenever you receive a 911 call, a display comes up on the console that indicates the origin of the telephone call?
Yes,
The address from which the telephone call originated?
yes,
And that same information comes up on another screen?
comes up on our status screen.
You know, I have here a single-page document. It appears to be some form of a 911 dispatcher's log. I provided Mr. Cochran with a copy. May it be marked People's 2.
All right, People's 2 for identification.
Ms. Gilbert, showing you what has been marked as People's 2 for identification. Do you recognize that document?
Yes, I do.
May I have one moment? I also have a copy of the document on the Elmo machine. May we project it on the screen, please?
Yes. Certainly.
How much you want to bet they're talking about that chair? They have more chairs than us. This clearly is not fair now. This is unfair trial. We need to start all over again. 4 degrees. It went up a degree since I started streaming.
All right, thank you, Counsel.
May I proceed, Your Honor?
You may.
Ms. Gilbert, what is the
Hold on. Take it down.
what is the document marked People's 2 for identification?
It's an incident form, what we determined to be an incident format.
Okay. And how was that form created?
On my working screen, which is the screen to my right that's directly in front of me, we have a format that allows us to create an incident by the computer by inserting certain commands. And I like to make a correction. It shows that I was on console 54. On the top line, it shows the time that I got the call. And the top example here is my update, so I need to drop down to the bottom It shows the top line, shows the call came in at 3:58. It has my operator number. It shows the console that I was on and the incident number created.
Now, does the form also provide a space for you to add comments?
Yes, it does.
And did you add some comments to that form in this situation?
Yes, I did. That's where it shows
Overruled.
it shows the update of my incident in the top example, and that was after I entered the comments.
And you did add those comments to this
Yes.
form. And the comments that you added to this form, were these comments based on your perception, your hearing?
Yes, it was.
May I, Your Honor?
You may.
On the screen. Looking at the bottom one-third portion of the form, and I'm going to ask Mr. Fairtlow, can you zoom in closer?
Overruled, same document.
Ms. Gilbert, what time did you say you received the telephone call?
3:58?
In 3:58 in the morning?
Yes.
And does the incident report indicate the origin of the telephone call?
No, it just shows, I have the ability to update it, and I have the ability to update the incident type. When I first got the call, I had it as an unknown trouble.
Okay. Okay, so the call came to you, right?
Right, it was the open line.
Okay, and could you hear anything over the open line?
No, at the beginning, no.
Okay. Did the line remain open?
Yes, it did.
And while the line was open, at any point in time, could you hear anything?
Yes, I did.
And what did you hear?
At first, I heard a female screaming, and that's when I went back and changed my incident type from unknown trouble to a screaming woman.
Okay. And did you hear anything else?
Yes, I did.
And what did you hear?
I heard someone being hit.
You heard a noise that you associated with someone being hit?
Yes.
And what did you do with that information?
That's when I went back and updated it to in the fact that I heard a female screaming, and then I heard what I thought was a slap. I went back and updated it as a female being beaten at the location to give the responding officer an indication of what was going on, that it was no longer unknown trouble.
In fact, you indicated that a female being beaten at location could be heard over the telephone.
Yes.
What was the next thing that you did after you updated the incident?
I brought up the necessary frequencies to broadcast it bureau-wide and for the air unit to assign a unit.
And did you assign a unit?
At the time I dispatched it, either there weren't any units available or I did an immediate dispatch, and I just broadcast it to West LA units.
And is there something called a call priority or priority code in terms of dispatching units to certain types of incidents?
Yes, it is. It's indicated to the right, far right, you see a C/P and a 2/H. That means code too high. And for the police department, that means a hot shot. That means immediate response.
You mentioned a moment ago that the telephone line was left open. Is that correct?
Yes.
Can you tell us how long that line was left open?
Well, only can go by my incident that I created, that the call came in at 3:58, and I updated it at 4:01. So I stayed on the line at least 3 to 4 minutes.
Okay. So the line was open then, 3 to 4 minutes?
Yes.
And the screams that you heard, you say that those screams were the screams of a woman?
It sounded like a female to me.
It didn't sound like a man?
No.
Could you tell who was being hit or struck or slapped?
No, I could not.
Overruled. She indicated no, she couldn't tell. Answer stand.
Are 911 calls recorded by the others?
Yes, they are.
And have you listened to the 911 call you received at 3:58 in the morning on January 1, 1989?
Yes, I have.
And when was the last time you listened to that tape?
Approximately a week and a half ago.
And when you listened to the tape a week and a half ago, could you hear slaps or strikes?
Overruled. You can answer the question.
I could, in remembering the call, I could determine after the first scream, then I heard someone being hit.
Thank you. With the court's permission, Your Honor, I'd like to play the 1989 911 tape.
All right, you have that identified as an exhibit.
Yes, it's been marked People's 1.
All right.
Emergency operator 461. Hello? You calling from 360 North Rockingham, apartment number B? Emergency operator. Okay, please hold on.
All right, whoever said Morse code is right. I hear it.
So from Wilshire, Normandy at the highest. Suspect one of the male blacks. 5'10", 150 to 1.
Ms. Gilbert, is that a tape recording of the telephone call you received at 3:58 a.m. on January 1, 1989?
Yes, it is.
And there's more to the tape, is that correct?
Yes.
Okay. And when you listened to the tape last week, did you hear your voice on the tape?
Yes, I did.
You testified a moment ago that you dispatch units to 360 North Rockingham?
Yes.
Okay. Is that on the tape?
Yes, it is.
Did you indicate that you dispatched units to 360 North Rockingham, apartment B?
Yes, it is indicated on there.
Could you explain to us why you included the apartment B directly?
When I first created the incident, I had not erased my screen from a prior call that I determined not to dispatch on, and had not erased the apartment number out of the field. When I went back and hit enter on a computer, it erased everything but the correct location that came up on the ANI,
Okay.
on the telephone console.
Now, we hear other voices, male voices, and apparently other dispatchers in this tape. Is that correct?
Right.
Those other voices, those male voices, those dispatchers, where is that noise originating from?
From people sitting beside me. There's people that sit behind me. Also, I had brought up the frequency to broadcast the call, and you were hearing the other divisions that were on the air because it was an open line. As long as I had not hit my transmit button, then you will hear all that.
In the comments you typed onto the incident report, marked People's 2 for identification, where you indicate that you could hear a female being beaten. At what point in this process did you type that information onto the report?
After I had made my incident and made it a screaming woman, and hearing is just, you get excited, you hear all of it at one time, and I went back and typed it in after that, after I had created the incident.
Okay. And is this while the telephone line is open?
Yes, I left it open.
So it's during the telephone call then that you typed in the comment about you're hearing a woman being beaten?
Yes.
Okay. And did the caller ever speak to you directly?
No.
Thank you. That's all I have.
Thank you.
Mr. Carpenter?
He can leave that up for you.
Good morning, Ms. Gilbert.
Good morning.
I'd like to ask you a few questions for Mike. The date of this incident was back in 1989, is that correct?
Yes.
That was January 1st?
Yes.
Was that January 1st, 1989 at about 3:58 in the morning, so that would be New Year's Day morning, is that correct?
New Year's Day morning,
All
yes.
right. As I understand what you've indicated to us, you received this call through the open line, is that correct?
Yes.
And you were sitting at your console, and being 911, you started to pay attention to that call, to listen to it, then you made some reaction, is that correct?
Right.
Now, from what you told Mr. Darden, you never had one of your colleagues?
That's one of my colleagues.
All right. Now, at some point, you type into, and you describe for us that you type into your computer, female being beaten at a location could be heard over the phone. And that was what you concluded after you heard this woman screaming, is that right?
Yes.
And you don't know whether there was a mutual fight or what was going on, do you, at that point?
No, I do not.
All right. So you just wrote, what you wrote down was what you concluded at that particular time, is that correct?
What I concluded that I heard.
All right, and that was back in January of 1989, right?
Yes.
You never at any time talked to any of the parties who were actually at that house?
No.
Just a moment, Your Honor.
Certainly.
Yeah, just a moment more. Your Honor. Nothing further, Ms. Gilbert, at this point. Thank you.
Just a few questions, Your Honor.
Don't go away.
Ms. Gilbert, you concluded back on January 1, 1989 that a woman was being beaten as you listened in on the telephone?
Yes.
And you've since, you've heard that tape again, that is since 1989, is that correct?
Yes.
And have your conclusions changed?
No, they have not.
Mr. Cochran just asked you a moment ago if there was information or other information on the tape that did not relate to this incident, and you said yes, correct?
Yes.
Okay. But you can hear on the tape your dispatch to any West LA unit, is that right?
Right.
That's a little further along on the tape?
Right.
Thank you. That's all I have.
Any recross as to that?
And so that it's abundantly clear, Ms. Gilbert, your conclusion about a person being beaten was based upon what you heard, and you couldn't tell who was striking whom. Is that correct?
That's correct.
All right. Thank you very kindly.
You're welcome.
All right, Ms. Gilbert, you may step down. Thank you very much.
May you be excused, Your Honor?
Yes.
May I have 1 moment, sir?
You may.
I just think this is a good time, guys. It's 50. We already did 52 minutes. Cat room court. Courtroom cat is about to begin. So we all want to be ready for that. We at least got to see a witness today. I know, that did go so fast. Court's open in 7 minutes, and I gotta be ready. I gotta get to work. I know, and that one witness is still on the stand. That's the link to Courtroom Cat. His stream starts in 6.5 minutes now. So, hop on over there next if you want to. I know, that was fast. I know, I gotta get my courts up and running. I gotta get my computer set up to start. Oh, guys, thanks so much for all 15 of you come out today. And the 85 other people that are going to watch this later today. I appreciate it. Thank you so much. I shall see you all again very, very, very soon. Bye, guys. Yeah, you guys stay warm, too. Don't worry about me. I'm warm. Bye.